Good afternoon, everyone. Welcome to our meeting of the New York State Board of Elections. Sorry for the delay, but business sometimes gets more complicated. I'd like to start off the meeting, if we would please, by introductions. My name is Jim Walsh. I'll be acting as the chairman of the board today. My left? Or my right? I'm sorry, my co-chairman.
It's all right. Doug Kellner.
Evelyn Aquila.
And Greg Peterson.
Todd Valentine.
Paul Collins.
Joe Burns.
Anna Savitsro.
Tom Connolly.
John Conklin.
Dan Valva.
Bill McCann.
Cheryl Kauser.
Bob Bremen.
Mary Greens.
Bob Warren.
John Lucas. Jeff Beely.
Amy Allo, League of Women Voters.
Thank you all. First item of business, the minutes of the January 12, 2012 meeting.
I move the adoption of the minutes as read.
Second.
All right, all in favor?
Aye.
Opposed? Carried. Unit updates. Executive, Bob Bremen, Todd Valentine.
Well, we continue to plan with our, they call it, it's been entitled the Restacking Initiative, which is the shorthand for the moving of the agency. So, you know, right now we've met with our Office of General Services design and construction section, and they're working on some plans for our proposed move to. I don't know if that's been announced publicly or not. So, yeah, well, moving, yes, but the location, I don't know. I don't know if they're releasing that yet or not.
To another state location.
Yeah, it's not far away, but we're working on the design plans because it could change. I assume we're still going there. They expect to have revised plans to our plan to us at the end of this week, and then we'll review that to see. There should be ample space in the area we're looking at. It's just then at that point we'll drill down for each unit to locate their particular employees within each little subunit of our own board. There should be ample space there. There's obviously space for boardroom meetings, for our regular conference space.
Any private offices?
There are. That's one of the pull factors to this location that did have that. There's a bit more privacy as far as that's concerned, and of course ample storage for the petitions, room for working on the voting machines, and we're also consolidating our storage. We have another off-site storage facility just north of Albany in another state facility. It's a rented facility. We'll be able to consolidate to this and save additional money.
What will be there?
It's a back storage we have for voter registration forms that get mailed out, and it's also back storage for campaign finance primarily, old petitions that until a destruction date comes up that we store there. So those will all now be consolidated into the same building, a different location than where we are.
Yes.
They'll be on a different floor, but there's ample storage space, so we'll be able to not only save the rent from our current leased space, but also we do lease space in that warehouse that we'll be able to consolidate to one location. So that would actually be unique. We'd all be in one building.
Yeah.
And we don't have any personnel permanently located at that warehouse, but we do have to go down there on a regular basis to not only file things, but also to retrieve documents out of our archival storage.
And to check out,
Yeah. So
somebody didn't throw everything out, not knowing who they belong to.
Well, our space is secured. Nobody's throwing it out. I mean, it is in a locked storage space, so nobody accesses it. And the same will be. There are provisions for a secure location segregated within this storage facility in this building. And we're continuing to work on with the Office for Technology to determine a location for the site, for the servers, for the databases that we run, and then for connectivity to the county boards to keep that operating in a smooth, seamless manner. I mean, obviously we'll have to go offline at a certain point, but we want to minimize that. And so we've toured, not me personally, but we've had several people tour a variety of locations that they've offered to house the servers. None of them are perfect yet. All of them need some type of work, either for space-wise, or we need to put security for our servers, or connectivity out to the counties and the rest of the world. connection between our downtown locations, which where we'll be, and where we're anticipating locating the database is at another end of Albany. That connection already exists, so a question of just making it work is all we'd have to do. But that's not settled yet either, and of course we're still waiting for the budget to be approved. Our proposed budget, which does have a lot of these savings already incorporated into it. So the sooner that we can complete the restacking, the less of an issue that we'll have going into the new fiscal year. And then we have everything else going on.
Bob?
One bit of good news, it doesn't happen often in the world of budget. The Federal Election Assistance Commission notified the states that there was another round of requirement money, a very small amount, for whatever state failed to use their leave of replacement money by the time that was extended under HAVA. If they didn't complete it by that date certain, they forfeited the money, and the Help America Vote Act had a formula to reallocate it to the remaining states. Our share of that is $79,173. We made application, as we would want to get our fair share. Completed all the application, and Tom Droz just gave me notice within the last 2 days that the money transfer has been received. So that is money that's here. We have the spending authorization under the state account to use that for whatever other purposes we have. So that's the little bit of good news we have. Other than that, we did have another follow-up meeting with the State Department of Motor Vehicle. They're working on a program as part of their review of mission-critical programs and the reduction in staff that they have through attrition and funding. They've identified the electronic voter registration activity at integrated during the DMV transaction as a priority that they think will improve services. So they met with us here on February 13th to review. They had a few questions, and we reviewed the process and what they were proposing to work through it. It looks very interesting as a way to really streamline those pieces of paper from the various DMV intakes directly to the County Board of Elections. When we look at the NVRA annual report, I don't know the percentage at the top of my head, but generally of the NVRA agencies, 75% of the paperwork comes from a DMV site on average. So that if we can facilitate that getting from a DMV site to the counties quicker and in a more efficient way that they can use it, I think that will help them. So they still are working aggressively on that program, and I thought it was a productive meeting. Other than that, I think it would be easy to say we spent a great deal of time since our last meeting working on various political calendars and responses to the federal court that I know is big on the council's agenda also.
And that's a good lead into our next introduction. Thank you very much, Bob. Todd, legal, Paul Collins, please.
Well, we filed an actual written report with the board, as is our wont
Thank
each
you.
month. Subsequent to the filing of that report, we received notice from the Department of Justice that our application for pre-clearance of the overvote screens devised by ES&S on an interim basis on both the scanner and the ballot marking device has received pre-clearance by the Department of Justice. That means in the special elections in New York City on March 20th, they will be able to use those screens, which is good news. Also, the actual overvote case itself has been resolved. We now have a court blessing of the resolution. Those screens have gone to the Department of Justice for pre-clearance as well. That's pending. And the big thing that we have pending with DOJ is the blessing of the Department of Justice's Section 5 pre-clearance unit of Judge Sharp's order of the June non-presidential federal primary in New York. But I fully anticipate that they will sign off on that in relatively short fashion. Finally, the appellate division has issued an order with regard to one of the 3 Nassau County election machine case appeals, and Nassau finally has to file a brief, I think, by the March 5th. So that's heating up. The Schultz case, which sought to ban any voting machine in New York, whether the old lever machines or the new electronic machines, they have filed their brief and appendix in the Second Circuit, and will file on or before March 20th our reply. Again, Commissioner Walsh, it's always nice to be on the respondent side because we won in the district court. And finally, the Gramalik case, which seeks to, or which sought to challenge the ban of the use of non-resident petition gatherers in New York, has been submitted on the 25th of March to a Second Circuit panel. Again, we're the respondent there, having won in the district court. And other than that, everything else is pretty much in our written report.
Thank you very much. Election operations, Anna, please.
Thank you, Commissioner. Good morning, good afternoon. In addition to our written report, we do have a couple of items to add. We're preparing paperwork that will certify the presidential primary ballot based on the outcome of today's board meeting. We are working with OGS on our contract renewals. That's quite an extended process, so we're trying to get involved in that as early as possible. We're looking at the contracts for the testing labs for Nysboe and also the voting systems. The voting system contracts have a 1-year extension in them, and that's been triggered. We're also discussing ways to consider the procurement of central count voting systems, so those conversations are just beginning with OGS. We are reviewing the regulations that are in existence that covered central count systems up until now. Bob Warren and John Ferry have reviewed those, and we're looking to make sure that every requirement in the old regs is covered by a requirement in the new Part 6209 and 6210 to make sure that we don't have any omissions, and that we've incorporated all the best practices that we've learned over the years using the central count system we have right now. We obviously worked through all of the objection process and worked with the council's office to review those items and prepare those documents for today's meeting. And I don't believe I have anything else. Joe, do you have anything to add?
Really?
Happy to answer questions if you have any.
Anna, there are 2 machine failure issues that are outstanding that have come up in recently. One is in the city of Tonawanda manual count. They discovered that there was a ballot in the ballot box that had not been recorded by the voting machine. And later on in the meeting, I'm going to comment more on the court rulings in the Tonawanda case. But it's my understanding that the Erie County Commissioners are doing an investigation, and I would ask that the State Board also get involved in that, because I think it's very important that we follow up on every single issue where there's a machine failure. And obviously a ballot getting into the ballot box without being counted by the machine is significant. I think the Erie County theory right now is that there may have been a paper jam, and somehow or other in clearing the jam, the ballot went through without the vote being registered. But I think we need to investigate that further. And then the other is the issue of the large number of overvotes that have been recorded on a machine in the Bronx. And I understand that Bob Warren is going down to the Bronx and is finally getting access to the election materials on that. And I would appreciate a report of what we know so far and exactly what we're planning to do at the state board level on that issue.
I can have Bob speak to that rather than me interpret how Bob has briefed Joe and I, so if you want to.
Could I have oh, I'm sorry, go ahead.
We're going to go down tomorrow, and I've talked to the Bronx and asked them to make available the election for that election, the ballot definition election, the images for that machine that were collected, the physical ballots that were marked, and they're going to have some extra ballots that we can have for tests, and they're going to have the machine there that's in question. We're also going to look at their test spec to be sure that they created their test spec properly and the results from the test spec processing. And what we can't get through, we're going to bring back with us all the images that they have so that if we have to do further examination, we'll have them here. And we'll try to determine whether it was a human error in designing the ballot, whether it was a printing error in printing the ballot, or whether it was truly a machine error. So it'll end up being one of those. Or, I mean, the other possibility is they are all overvoted ballots. And then it's a question of, is it usability or design of the ballot that caused the problem? Because this is from the 2010 governor's election, and I've been doing some analysis on some of the other counties that had some incidents of overvotes. And some you could make an argument that may have been caused because of the wrapping. These are on the landscape, theirs is the portrait, so it may not come into play on theirs.
Paul, what I wanted to ask is that are either of these cases, the overvote in the Bronx, or maybe Paul would have to answer this, or the Tonawanda case, are they part of any of these lawsuits that you just mentioned? Isn't there a lawsuit to say
certainly.
we just go to the paper ballot?
No, certainly, Evelyn, Commissioner Aquila, the overvote case, which was brought by the NAACP, within the context of discovery in that case, New York City was obliged to reply to discovery requests from the NAACP, and that's when this anomaly in the 2 scanners at one poll site in the Bronx came into play. The case has been resolved as against the State Board of Elections. It has not been resolved as against the New York City Board of Elections, and is ongoing in the event that there is some unwillingness on the part of the New York City
Yeah, I
Board
had heard that. That's
to
why I
implement
wondered. Yeah.
the new
You
warning
answered.
screens that we have agreed on with the plaintiff. That's the Tonawanda case is not on our radar screen. It involved a local election out in Erie County.
Bob, I have 2 additional items that maybe
Thank you.
you've already considered on this. One is, will you have access to the original Canvas reports, the original Canvas tapes, to confirm that the Canvas tapes actually showed the numbers that?
I didn't mention that, but I can call them when I get downstairs.
Okay, and then the second is to review New York City's procedures, their post-election procedures, not just following the letter of our post-election testing rules, but also whether they have anything in place so that when there are anomalous results, that would trigger a special review. And it seems to me that when you have an anomaly of that size, that it should be handled
Something should happen.
something differently than just ignoring it and using the same machine a second time without following up.
Okay.
Do you think, Bob, it could have just been a faulty machine?
It could be. It could be people actually overvoted that much. Like I said, I did notice that the wrapping does seem to appear that it caused people to overvote that may not have overvoted. You don't know for sure, but
Maybe we need to explain that a little bit, because when you have the horizontal ballot, which is used everywhere except in New York City, where the candidates are listed by political party across a row, so that right now all the Democratic candidates would be on row A, all of the Republican candidates would be on row B, and so on.
So when there aren't enough rows for all the parties that are available, then you have to you have to add a second column, like in this case for the governor's race. Then you start from the bottom, wrapping the candidates coming up the ballot. So for somebody that may not have been paying attention, they could easily just think it's another column. They're just marking as they go along. They mark in every column that they see and go on their way.
Now, that doesn't happen to that extent in New York City, because New York City uses a ballot on the opposite axis, so that the political parties are listed in columns.
Yeah.
And the ballot only has 8 columns. And in New York City, for many years, we have had the procedure that the first 2 columns are reserved for the Democrats and the Republicans, whichever
Right.
gets
Yeah.
column A.
Yeah.
And the wrapping only goes in the 6 columns to the right of those, so that if they need 2 or 3 rows, there will not be a minor party candidate listed in what would appear to be column A or in column B. And so you don't have that. So if somebody's voting a straight ticket, it's
Yeah,
obvious
vote down.
that, and I think that's another issue of ballot design. I don't know whether you can incorporate that same procedure in the landscape ballot that everybody else uses. But it certainly would avoid the problem, because leaving the first 2 columns blank highlights the fact that it's a single office and that there are multiple rows.
Well, in a sense, that's what we do,
used.
because we begin from the bottom up.
Right.
So you never get up to the top. Where the two major parties would be.
And you're saying all the overvotes occur in the other parties?
They occurred in, it would either be Democrat, Republican, Conservative, then somebody would have a mark down in the
Yeah.
Taxpayers Party or
Right,
something,
yeah,
because it was in
yeah,
that other
right.
column. So they were just going, here, 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 and just across. Some people voted straight across on the row. They did a straight party vote across at the bottom. There were just various things that you could look at the ballot, and you're only assuming
Yes.
that the person didn't do it intentionally.
And it shows you the overvote that way.
Okay, well, I look forward to getting a detailed report on the New York City Bronx overvote situation, because I
But I
think
think you
that
got the right thing.
it's significant.
Okay.
Oh,
Picked up.
bonus.
All set?
Thank you.
Our NDRA PIO, John Conklin.
Thank you, Commissioner. I don't really have much to add to the written report. Just wanted to highlight that Tom and I have been working on the restacking stuff as well with Bob and Todd. In George's absence, Tom and I have kind of been working on some decisions with IT, and we've been involved in visiting the sites for where the servers may be, so we've been doing a lot of that kind of stuff. Just wanted to highlight that. Do you have anything to add, Tom?
No, we're good.
Thank you, gentlemen. Campaign Finance, Bill McCann.
Thank you, Commissioners. Just a couple of highlights from our report. We did file for the January periodic, our order to show cause on the 23rd, and that's returnable in March on the 22nd. We named 511 filers for failure to file, and we'll do our normal processing of that. We did complete our initial beta testing for our operation system neutral software, and they're doing a post-use analysis, and that's going well. We're waiting on a response for our continuing legal education application, which takes several months in the normal process, so we hope to get that approval in line with our seminars, which we're scheduling now for the spring, which take place in May and June. Also working on our filer update, which we send out each spring in anticipation of the seminars for all of our filers, as well as making any modifications to our handbook, and again, working on our seminar schedule. So that's all going according to Hoyle. And then last but certainly not least, Our independent expenditure regulation was mandated by Chapter 399 of 2011. Were published in the State Register on February the 22nd, and that public comment period runs through April the 9th. And so we'll wait and see what comments we get and then provide that to the board at the appropriate time. And that's our report.
Any questions? Thank you.
Thank
ITU,
you.
Dan Valvo.
Nothing to add to the our submitted report. What I was going to add was preempted by both Todd and John, so there's nothing to say.
I'll give you a third of the credit for that. Under old business, discuss the 2012 proposed legislation. Paul Collins.
Well, Kim is not here, and she's sort of shepherding that drive, so I'm going to defer. Okay?
That's fine.
All right, well, I have two things I wanted to comment
Well, I
on.
think for one, just at our meeting that we discussed this last, which was 2 meetings ago, I believe, you requested that we send it out to the Election Commissioners Association. So we had sent that out to the officers and the legislative committee because they were having a meeting. They were going to discuss it and share the views. We did receive a couple of comments back that I know Anna and Kim, when she's healthier, have to review. They weren't very substantive. I mean, there were some issues that they recommended, but it wasn't extensive, substantive in order to incorporate their views. But other than that, I think we still have some work to do internally on a bill that looks at the. I mean, that one's pretty close, the Article 9 bill. It just a matter of a couple of days. There's some couple of issues with the usability that we need a little bit of time just to sit down. That shouldn't be overly complicated to try and deal with some of the recommendations that are out there to what better can we do to make the ballot a little bit easier, especially from the instruction point of view. I think that's where we've seen a lot of information from some of the groups. Even when we read those instructions, they're quite laborious, and if we can recommend some ideas there. But other than that, I know that's what we've been working on since our last discussion on it.
Commissioner Cohen?
So I hope that we can get the staff to make this a priority now, to get this done with the next meeting. Basically, the outlines of this were submitted in November, and I've been raising it each month, and we keep putting it over. Before we know it, the legislative session's going to be over, and it's going to be too late. I think it's important to address this. The other thing I'd like to do, if you bear with me, is just to review for a minute my reaction on the recent city council race in the third ward in Tonawanda, which resulted in litigation that was eventually resolved, but I think there were significant issues that came up that are worth reviewing. In that race, the initial canvass of all ballots, including those scanned at the poll sites, the optical scan was the ES&S DS-200, and the absentee military and provisional ballots, which are scanned on separate scanners at the Erie County Board of Elections, had a race that recorded 435 votes for candidate Beyer and 434 votes for candidate Sliz, with 31 ballots that were deemed blank or void. So the losing candidate, Sliz, commenced a proceeding in the Erie County Supreme Court pursuant to Election Law 16-113 to obtain a manual audit of the voter verifiable audit records of all the ballots cast in the election. And the trial judge initially dismissed the proceeding, essentially for failure to state a cause of action, relying on the Court of Appeals decision in Johnson versus Martins. That was the 2010 decision over the Senate race, where the Court of Appeals had ruled that the discrepancy rate, that there's no manual count when the discrepancy rate is significantly below the margin of victory, such that there's no substantial likelihood that the result of the election would be altered by the conduct of a full manual audit. Now, this year, the appellate division in the Fourth Department reversed the ruling of the Erie County Court and remanded the case for trial. And although the appellate division did not address Johnson versus Martins, the court did note that it was undisputed that there were no unresolved discrepancies during the mandatory audit, and thus no basis for a further verifiable audit record under Election Law 9211 or our Regulation 96210.18. And then the court went on to note that the petitioner had not alleged any of the discrepancies defined under Election Law 92083. And so the only basis for a manual audit is that there is, quote, a likelihood of a material discrepancy between the manual audit tally and the voting machine system tally, which is the language of Election Law 16-113, Subdivision 2. And then the appellate division added, because only one vote separated the two candidates, the petitioner is contending that there's a substantial possibility that the winner of the election is reflected in the voting machine or system tally could change. And the appellate division ruled that the losing candidate should be given an opportunity to prove the case, even though it didn't actually order a manual count. So on remand, obviously there was a considerable interest among election officials throughout the state because New York doesn't have any black and white guidelines on when a manual canvass is appropriate. And right now there is no statewide standard, and most counties have no standard at all, with two exceptions that I know about. Columbia County does a manual canvass in every contest. And New York City has a written procedure that requires a manual canvass where the margin is less than 0.5% or 10 votes.
I sat there and did many myself.
So my own personal view was that there should be no dispute that where there's a one-vote margin in any contest, that's close enough to trigger a manual canvass. The Erie County Commissioners, who I think acted very responsibly and thoroughly in this process, Dennis Ward and Ralph Moore, were aware that any decision that they made should be part of a formula that would have a binding precedential effect. And I think they were also concerned about equal protection issues of having a county set their own standard without any statewide standard, because then you get into issues of is everybody being treated the same throughout the state. Eventually the candidates who felt they were spending undue resources for a relatively inconsequential local office decided it wasn't worth further litigation and conducted a manual canvass. And because it was conducted on consent, it doesn't have any real precedential effect. But the actual results of that manual canvass still force us to take notice of significant issues, because in the manual canvass, 2 votes changed. We already discussed one of them, where the Erie County Board had previously noted that there was a missing ballot. And it turned out that there was one more ballot in the ballot box than the machine had recorded. And it turned out that that ballot was for candidate Sleeves, so that brought the race up to a tie. And then there was a second ballot that the scanner had counted as a blank vote, but on looking at the ballot manually, the voter had circled the candidate box without putting any mark inside the voting bubble. So the machine correctly didn't count it, but under our rules, because the voter's intent was clear, that counted as another vote for the candidate whose name had been circled, and that gave him a 1-vote margin that actually flipped the results. So what this illustrates is that while our machines have an excellent record, out of the audits that we've done so far, there's only been one ballot out of the millions that have been audited where the machine miscounted the ballot, and that was because the ballot was wet when it went through the machine, and it came out as a blurry image in the images. But we see this issue of where there are paper jams or perhaps some other explanation where ballots can get into the ballot box without being recorded. So that's one example here of a problem. And because this is a real issue, I think it highlights for us the need to develop a statewide standard on when a race is so close that there should be a manual canvass. And I think it's a subject that we should be talking about, that we should get the political parties and the election lawyers to talk about and try to come to some agreement on a standard so that there's a single statewide standard and not something that's as obscure now as just saying the possibility of that it would change the outcome.
No, I think we should. I think that's very good.
And then the second thing is simply a comment that I have for election practitioners is that the ballot images are recorded. It's relatively easy to gain access to the ballot images for the image scan machines. It's more difficult to gain access to the images for the DS200, although I understand that one of the projects we have in the works is to make it easier to get the ballot images for the DS200. But that one way of addressing this issue is that if election lawyers get discovery of the ballot images, then the burden on finding the miscounted ballots could be on the lawyers, and that they should have to go through the ballot images and say, hey, I've found X number of ballot images of ballots that, applying our rule 621015, should be counted differently than the machine counted. And that would spare the Board of Elections the obligation of doing a manual count, and place the obligation, at least in the initial level, on the candidate who's challenging the results of the canvass to show that the ballot images would reveal a change in the result before it goes to court. I'm just throwing these out as ideas that we should explore. I appreciate your patience in bearing with me on that long presentation, but I did want to make it for the record so that we get this discussion
Could I make
started.
just one very quick remark? I agree with both of your suggestions. I just wonder, is there anything at all in the state law that restricts us from doing that the counties have the right?
I think clearly the uniform standard would be what we're looking for. There's a question, even when I talked with Commissioner Ward yesterday, that he gets into it. Is it clear that it's a county by county authority, or is it a state authority?
Well, that's
and
what
if it's
I
county by
just asked,
county, you're going to have contests that go beyond a county border that are going to be counted differently from county to county. So whatever the standard is, makes sense to do it statewide. I mean, clearly, since we have absolutely no recount provision in the statute whatsoever, everybody is mining the field of the audit, trying to find a way to use the audit to get a recount, as opposed to an expanded audit. So, a lot of the issues in the wording of the statute, looks to, you had to detect, you have to prove that you've detected an error, and the error is projected to cause the change. Well, if you've done a small audit and there is no detected error, then it's not easily, it hasn't been successful in getting what they want, which is a recount. I mean, everybody calls for the recount, and then they mine the only section that lets them, which is the audit. So a clear standard, even from talking to Commissioner Ward, I didn't get a chance to talk to Ralph.
Well, Bob, this
It
was
was
an
clearly
issue.
what they're looking for, so that they don't get into a problem where, we just want to do what we're supposed to do, we want to do it right.
Bob, I remember many years ago, we discussed this, having a statewide requirement for when there would be a recount. And at that time, we abandoned it because it seemed that, it seemed to be the right of the, it seemed to be, belong with the counties, whether they had a right for it at that time or not, but it seemed to belong there.
Well, it's it's kind of a two-part problem because we have no spot at the state level for having accurate or reliable interim results. You know, for those counties that use the portable memory device, you know, you have to be able to get the numbers when if it's totally within the county. And when we had the audit provisions that Howard Stanislavic and others were calling for, we had a great discussion at the time because what they were looking for us to put in place wanted to be triggered based on how close an election was, and we have no way right now of reasonably, we have enough trouble getting it by the 25-day deadline for you to certify, much less an accurate preliminary number that goes beyond a county that you could then say is the automatic trigger. So you know, the hard part is, I guess, for New York, where our audit is upfront. Some of the other states that have that provision, you certify the results, then you do the audit, and then you use the results perhaps to change the certification. Ours has to be completed before we can complete the certification. So it's kind of, we would need some way when the contest goes beyond the border to reasonably know a number. So that's why we kind of, the number is important and the process is important. And it literally is, you know, after every election we get these calls, and
Yes.
it's something that hasn't been addressed yet, and either we come up with a process that we can work with, or perhaps the court will have a hodgepodge across the state.
I feel we tried to address it. We tried to address it several years back, but it got nowhere because of some of the problems that we just stated. I would think it's something that we should absolutely do, and I believed at that time it was. But I think that considering what are we having, 3 or 4 primaries and a general election, maybe we need to do it starting December for the next year. I mean, we could. I don't know if there's enough staff here to, or reaching out to the counties at this time to work with us on this. It may be a hard time. It might be a difficult time, but it absolutely has to be addressed. But we had to take it off the table several years back. You might have been on the board at the
That
time.
sounds familiar, yes.
Yeah.
Thank you, Bob.
It's a great idea, though, and important.
Under new business, our vote on petition rulings, we have 2 votes to conduct here. One is on the large sheets of paper you have. We'll accept the motion to accept the staff report regarding the objections that have been filed with respect to the presidential primary.
So moved, and it's not just the staff report, but they're the draft determinations that were also
Sure.
circulated. Right.
Second?
Second.
All in favor?
Second.
Aye. All opposed?
Aye.
Carried. Second item, we have a motion to invalidate the request to appear on the Republican presidential primary ballot by Rick Santorum for failure to complete set of delegates and alternates as required by statutes, subject to curing by filing a complete slate. You have a motion?
I'll make that motion. And just by way of...
Second.
I'm sorry, a
Go.
second?
On the question.
Just by way of explanation, we got a letter today from Maylin Tan of Flushing. I'll just read it so that we have a clear understanding as to why his slate was not complete. She says that it has come to my attention that my name has been submitted by Rick Santorum as a proposed alternate delegate to the 5th Congressional District supporting his candidacy in the New York Republican presidential primary. Please be advised that I never consented to this submission and that, in fact, I do not support and am not committed to Rick Santorum's presidential candidacy. Please remove my name as a proposed Santorum alternate delegate from the 5th Congressional District. Thank you for your cooperation. That's signed by her or him. That being the case, that leaves the slate invalid, and we have no choice but to pass a motion like this, subject to them curing it.
And Commissioner, just so we run through the legal issues here, it's my understanding that the statute that applies here is Election Law 2-122B, which is the the method for presidential primary nominations that are used by the Republican Party, right? And under subdivision 3B, that the two Republican commissioners have certified the candidacy of Rick Santorum as a person who's nationally known and recognized.
That's good.
So then we go down then to subdivision 3D, which says that that the candidate who's met that requirement has to file a certificate with the State Board of Elections providing a complete election, wait a minute. Providing a complete election prioritized list of proposed congressional district delegates and congressional district alternate delegates supporting and committed to their presidential candidacy for each such position from the congressional districts to be elected at the primary election. So, again, it's my understanding that that Rick Santorum initially filed that list, and there were many defects on the list, right? There were, that he received a notice to cure on February 22nd with a list of the, well, what is it? It's almost 2 dozen delegates that were invalid. And that after receiving that notice to cure on February 22nd, the Santorum campaign then filed a new list that attempted to cure. But the new list, but then just this morning, the State Board received this letter from the candidate.
Alternate delegate, Maylin Tan.
So the commissioner read. And so, so therefore, it would appear that that in fact the Santorum campaign has not filed a complete list of delegates and alternate delegates supporting and committed to the presidential candidacy, and therefore we go down again to the statute in that same subdivision. It says that that the State Board shall review each slate, and if it determines that the slate is not complete or is not otherwise in compliance with the provisions of the paragraph, it shall notify the presidential candidate of any defects forthwith and provide such presidential candidate with 5 business days to cure any defects. And since we only got the notice from this delegate this morning, that was not on the original list to cure. So by this resolution, we're giving the Santorum campaign a second attempt to cure, which we ordinarily wouldn't do. If it were on the first list and he hadn't cured, it would be too late. But since it wasn't on the first list, we're giving him this cure opportunity. But then also, we've discussed among ourselves the fact that March 1st, which is this Thursday, is the deadline for the State Board to certify the ballots to the county board so that the ballots can be printed in time to be mailed to military and overseas voters. And so even though the statute gives the candidate 5 days, the candidate is off the ballot until he cures, and if we don't get the cure before the March 1st cure date, then the board will certify the ballot as it is. If we do get the cure before March 1st, then that'll be on the certification that goes out.
March 1st is too late? I thought they had March 1st. I don't know.
By March 1st.
If he hasn't,
By March 1st.
Paul, have I overlooked something in this?
Respectfully, Commissioner, and I don't want to go down roads we shouldn't go, but an obvious question presents itself. if prior to March 1st, we receive a piece of paper purporting to cure this defect, that's terrific. Who is going to make the determination as to whether it does cure the defect?
Well, it'd be the initial determination like we do in this file.
Okay?
Right. Well, no.
In the past,
The staff, the board.
the staff, okay. I think the resolution ought to cover that issue because that's an obvious question.
But it's just
Very
like,
honest,
it's just like it's an initial file, the board doesn't rule on the initial filing, they only rule on the rejection with regards to ballot determinations.
I mean, we've had cures in the past, right?
Yeah.
Cover sheet.
We've had
notices.
cure provisions in the past that are
And
not,
in the past, who rules on whether or not they're cured?
the staff.
Staff.
The staff does. Always the staff.
Yeah.
So it would be the same process. So if the
As
cure
long as the
fails to come
process
in,
is clear.
I think the determination's been made, and it's only if something's wrong with the cure, I suppose you'd have to bring, we wouldn't have to come back, it didn't make it.
Right.
It's my understanding that there is a representative of the Santorum camp driving up a substitute today, which is allegedly been promised by 5 o'clock this afternoon. Now, obviously, they didn't do their homework, which is why this thing came to our doorstep today. And there certainly needs to be a better delineation of what is required of candidates in order to put their name on a ballot. Certainly not willy-nilly just grabbing somebody and throwing their name on a ballot and keeping your fingers crossed that they're going to accept. There should be some sort of certification by those who are named that they have indeed accepted that, which would make our job a lot easier, and then certainly this kind of situation would not present itself. It's always difficult to turn around and say to someone that, sorry, you don't qualify, and often I know in New York we have been criticized for what allegedly has been picayune's detailing of the process. However, in a situation like this, where there's obviously somebody who has said, hey, you didn't ask me, I don't support, get my name off, that lays it in our lap to do the right thing, and frankly, at that point, your delegate list is not complete, and you're off the ballot. So as we vote today, at this hour, and assuming that that's what happens, bottom line is he's off until that's cured, and I assume hopefully by this afternoon that they'll have found a cure for that. But obviously there is a defect in the process which has to be addressed within the next 4 years.
We could tease you and say the democratic rules. The democratic rules require a written.
You know what? And I agree with you too.
But the key words here are that the statute requires that the delegates be supporting and committed to the presidential candidacy, and in view of the written statement of the delegate that she's not supporting Santorum, I don't think we have any choice but to send them the cure notice.
Well stated,
so we can
everyone.
vote. Thank you.
Thank you all. We have a motion made and seconded. On the motion, all in favor, please, say aye.
Aye.
Opposed? Carried. Item B, meeting with Chief Administrative Judge regarding the 2012 calendar issues. Bob Bremen, Todd Valentine.
I know this is on the agenda, we talked about it briefly, and before, I think it's one of those items that in the past, the board has attempted to reach out to the court to go through the calendar issues. I think it's helpful to redo that, assuming we have a stable political calendar as it speaks. Just because there's so much change, it would really behoove us with the compressed calendar to meet with the court, explain to the court the calendar and the pressure that to meet those deadlines and any processing order that the court could consider. It may help us tremendously. I know it was something we discussed when we put together the waiver application. While the application was not accepted, the concept is still a good one, and I think it would be helpful to do that. And I'm going to guess it probably would take more than once this year because I'm not 100% sure the calendar is all that well set.
Well, we need to open a dialogue with regards to this year specifically because there are so many elections that are occurring where court intervention may occur, and the court needs to be apprised of the timetables that are involved. That is different than previous years. I mean, I'm sure they read the press reports, but we need to get them to focus on that and just get that dialogue opening. Now we may start with a letter, obviously, introducing the subject, and then go from there and see what they're going to do. But we have done this in the past to meet with the court system. Not really remind them of their obligation, but explain the situation so they understand the need for finality, and so that we can get ballots out and get voted on. So.
There are three things that I would like to emphasize in approaching this, and I think that Judge Prudenti will be very responsive, that she has a fair amount of election law experience and will understand these issues. The first is the calendar issues that you've discussed, and obviously we don't really know what's going to happen because the primaries could really happen any date between June 26th and August 18th. It's really up to the legislature if they are going to get around to combining them, and so it may be premature yet to talk about the calendar issues. But the second thing is something we've discussed, is to emphasize to the courts that there needs to be a real date that is the last day that the court can order a change in the ballot, because of the nature of the scanning machines. It's not like the lever voting machines where you can do an order the day before the election and get compliance. And I'm of the view that we would be well served by getting bipartisan agreement in advance on what that cutoff date really is, so that there's no argument later on by one side or the other as to whether it's feasible to reprint ballots and do the necessary testing in order to change the machines. But the one thing that to me is absolutely critical is that no voting machine should be used without having gone through the logic and accuracy testing that's required by the statute and our rules, notwithstanding a court order changing the ballot. And then the third issue is to ask if Judge Prudenti would be willing to send a reminder to the judges that election day orders, such as the impoundment orders that are typically sought ex parte, under the court's own rules, are required to be on notice to the boards of elections, and particularly where these orders suspend the operation of the statutory scheme, that the judges should not do that as lightly as they do it now. Just because a lawyer submits an order that alters the statutory scheme on how the ballot should be canvassed should not be taken without notice to the boards of elections. So I would hope that we could include that in our dialogue with the administrative judge.
I don't think you're going to get a yes on that.
They put the rule in that says, I mean, there is a court rule that says you're not supposed to do it ex parte.
I know, but it's going to happen.
And it's just the need to...
A lot of people rush into the court, that night.
Well,
and it becomes chaos.
We did get one last year that was a surprise to us, that, well, not a surprise that out of all of them that we got, one actually followed the rule, so it was different. And it seemed
That would be Judge Lynch from
it worked out.
That would be Judge Lynch
You're a
from
good
Albany
friend.
County.
You're a good friend.
It made for an interesting hearing. They got through the process. Everything worked, following the rules also.
well, in the last 2 years, we've gotten ex parte orders that and And at least we were successful in talking to the attorneys who submitted the orders to get them to reinterpret their orders to comply with the statute. And, but I think that's less desirable than at least alerting the judges in the first instance that they shouldn't be
Well,
signing
we
those
should ask
orders
for it.
without
We should ask
checking.
for it. And I don't see much hope in getting it done.
All right, thank you very much.
All right, thank you.
Item number C, vote on a resolution to authorize additional expenditures of HAVA funds for court-ordered voting machine modifications and testing. Ann and Joe Burns, any comment?
Well, I move the resolution. I
Okay.
think it speaks
Yeah,
for
because they
itself.
just got the money.
Have a second? Good. All in favor?
Aye.
Aye.
Opposed? Carried.
Thank
There is no need for executive session, I believe, is there?
No?
Well, there's one case.
There was one case and was asked to be held over. That
Oh, it was? Oh, I
Oh, that's a
didn't know that.
preliminary
Yeah.
determination? Okay. Set the date for our next meeting?
Assuming we still have
That one, you're the most
a
important.
primary filing period that's occurring, we would target our next
No, this is for you.
Oh, for
meeting
me.
for
I know, exactly.
Thursday, May 3rd is what we're looking at to make, it'll be, other business, of course, to be
No,
conducted,
no
but,
March or April?
well, the beginning of April, you have
No, that's okay.
Easter, so we have Easter and Passover we have to deal with, then we have the filing period on the
Okay.
10th to the 16th is currently scheduled.
Oh, okay, with
Then
everything
allowing-
coming in, yes,
Then
I'm
allowing
sorry.
2 weeks for objections and specifications. Assuming this is all still going in that calendar, that's how we calculated, that's how we came up with that week.
Yeah,
Um,
no, I understand that.
Well,
Yeah.
May 3rd is fine, but my problem is not getting the legislative package done.
Well, it has that issue too.
And I think we should meet monthly.
Will it be ready by May 3rd, do you think?
No, we should do it in April. We should meet the first week of April.
That's Easter, isn't it?
That's the second week.
Second week?
Yeah, we could target.
Meet on that Monday, if,
Is this just
so
for
we
that
don't
one
conflict
item?
with
Is that-
Passover.
No, Monday's
Just
the
so-
day,
It'd be a
honey.
regular.
I would prefer to stick with Thursday, Tuesday or Thursday, if we could.
What?
April 3rd or 5th, you mean?
Well, if I thought we would have the legislative
Third.
package done without setting a deadline for the meeting,
There's some way we can accomplish that?
well, and why don't we cancel the meeting then if we get it done?
We could schedule it for the 5th of April.
Commissioner Clark, the 5th of April is Holy Thursday.
No,
Oh,
the 12th
Yeah.
is holy.
No, 5th
No.
is right.
no,
You're right.
I don't, yeah.
No.
No, we're not going to have it on Holy Thursday.
Yeah.
I thought that might be of some concern.
My little CCD children.
No,
know
it
how to
should be
see
the
it.
second or the third.
Third. How about the 3rd?
I would prefer Tuesdays to Mondays.
You prefer Tuesdays? I do too, yeah.
I can't be here.
You can't be there on Tuesday?
Not that Tuesday. The 3rd of April?
We do Mondays.
The second?
Second is very bad for me.
Second I have.
The second is very bad. But if I have to, I have to. I'll have to cancel something.
It's,
Nobody's liked Wednesday the 4th so far. I didn't know if that
Wednesday.
meant it was already bad with
How's
someone.
Wednesday?
Wednesday I have.
Yeah, no, I won't have CCD on the 4th.
Oh, you-
I won't have it on the 4th.
Well, then why
because-
don't we do Wednesday the
Yeah, yeah.
4th?
That's
Okay.
okay.
no, this is still pending, that if Doug's
Right, we
request-
can, if we can get this, the legislative package agreed to before then, maybe we can,
We could go back to
Postpone
the
the
May
meeting.
3rd.
that we don't need to all come to Albany.
We'll
'Cause we don't
also-
need to
we'll still-
formally
still gonna be
vote.
a meeting on May 3rd.
Okay,
Right,
we'll
yes.
keep that. That's a definite, May 3rd. And the 4th is if needed,
Okay.
right?
Yeah, and if now if the schedule for the primary changes, which is
Possible.
Yeah, I know.
then we'll have to adjust the May meeting.
Okay.
Because that's timed to occur, to allow us time to process any objections.
That's the last day we have to certify.
But let's see if we can get agreement on the legislative package so that we don't need to come in April. Otherwise, I think we need to come, because if we don't set a deadline, it's just not going to happen. It's 6 months now.
May 3rd when we keep.
Yep.
Is May 3rd all right for you?
Yes.
Okay.
Have a motion to adjourn, please?
So moved.
Second? Second. All in favor? Aye. Opposed? Carried? We are adjourned
Aye.
until
Aye.
April, whatever.